Good evening, ladies and gentlemen, and welcome to the Underground Railroad, Myth and Reality, a professional development webinar sponsored by the National Humanities Center's America in Class. I'm Richard Schramm. I'm the Vice President for Education Programs at the Humanities Center, and I'll be moderating this evening's session. Before we get underway, let me introduce the center briefly. We're an Institute for Advanced Study located in Research Triangle Park, North Carolina. Our main program here is a fellowship program that brings scholars from this country and abroad to the center to research and write on topics in the humanities during the course of an academic year. We're distinctive among institutes for advanced study because we have maintained for many years a vigorous outreach program to teachers. You have discovered our webinars. You can discover all of the other resources we offer high school teachers of American history and literature by going to americainclass.org. That will land you on this page, and from this page you can gain access to all of the resources that we provide for you. This is the final webinar we'll be doing in the fall of 2015. Our spring webinar schedule is up. Please check it out. We're going to begin next winter actually, in January, with a three-part series on war and literature. We'll be looking at the Red Badge of Courage, All Quiet on the Western Front, and the things they carried. Then we move on to looking at key stories from Ernest Hemingway and William Faulkner, Toni Morrison's The Bluest Eyes. In partnership with Primary Source out of Boston, Massachusetts, we'll be looking at East Asia and the Cold War. Then we go back in time to look at, to remember the 1960s and the 1950s. Then we look at religious freedom and religious intolerance in America, a very timely topic. We urge you to please sign up for that. Then we ask a very simple but complex question. Who started the Cold War? We look at Edward Hopper, the American realist, and end in April with Jack Kerouac's novel On the Road. Let me point out another resource that we offer you that is particularly germane to this evening's topic, our brand new lesson on the Underground Railroad. You can find that at americainclass.org/the Underground Railroad, or you can just go to America in Class Lessons and find it there. As you see, it answers a fundamental question: as the Underground Railroad helped guide fugitive slaves to freedom, what dangers and challenges confronted both the fugitives and those who helped them? We'll be talking about that tonight. Our professor, Matthew Pinsker, our leader of the seminar this evening, helped us develop that. I think you'll find it really useful, and it also offers some challenging interactive exercises that you can work through with your students. So please check that out, a brand new lesson from America in Class on the Underground Railroad. Also, check out our Pinterest page. There you will find our resources, plus the resources that we aggregate from a variety of other institutions. So please check that out. I think that will help you with your teaching. Now, this evening, when our seminar is over, if you'll go back to the Underground Railroad website, there you will find a recording of the program plus a PowerPoint. We invite you to plunder the PowerPoint, use it in your classes if you'd like to. That's what it's there for. You will also find an evaluation. Please fill that out for us and send it back into us. That's very important. We pay a lot of attention to your evaluations. Once we receive that, we will send you documentation of participation that you can submit to your local certifying authority to obtain whatever recertification credit your participation in this webinar warrants. How do you participate? I'm sure most of you know, but for those of you who are new, let me explain. Professor Pinsker will be making comments throughout the evening, and we'll be stopping from time to time to ask questions. To respond to those questions, please put your cursor in that box that I've bracketed there in green. You'll find that at the lower right-hand corner of your screen. Type your response, hit that send button to the right, and it will appear in the large chat box above. I will be following the chat all night and bringing it into the conversation at opportune moments. But please do not wait for us to pose a question. Don't be afraid to ask your own questions or make comments. Give us feedback on how you would teach the material. The cardinal rule of our webinars, ladies and gentlemen, is that the more you participate, the better the webinar. So please, get those questions and comments to us. They really make the program interesting. We look forward to those. So let's get underway. Our professor this evening is Matthew Pinsker. We're delighted to have him with us. He is Associate Professor of History, the Pohanka Chair in American Civil War History at Dickinson College. He is an Abraham Lincoln expert, and a number of you have been, I see from the chat, in his summer seminars on Abraham Lincoln. We'll have to get him to do a webinar on Lincoln for us. You see his work, some of his works there. I want to point out another one that he and his colleagues at Dickinson College have put together, House Divided. It's an excellent website on the Civil War and will provide you with an enormous amount of material for your teaching. So let me turn the program over to Matthew. Let me turn on his microphone. Okay, Matthew, it's all on. So please help us separate the myth from the reality about the Underground Railroad. It's all yours.
Okay, thanks, Richard. Can you hear me? Can
Yes,
you
we
hear
can
me?
hear you. We can hear you perfectly, loud and clear.
All right, great. Well, it's good to be here. Obviously, feel free to call me Matt. This goes for everybody. And I'll just start by taking us into this whole idea of myths and realities of the Underground Railroad. Um, the the first myth that I think many of us have absorbed over the years, and some of us teach, is that the Underground Railroad was secret and it left no records. Now, there are certainly records available. This is the best and most exciting news of all. In the last 15 years or so, most of those records have been digitized, so they're totally accessible to classroom teachers. Now, whether or not you want to characterize the Underground Railroad as secret, that's not necessarily a myth, but I do think the latest scholarship will help you see that the story here isn't really about the secrecy of the operations, the passageways, the tunnels, the safe houses. It's about the open defiance of federal law that existed in the North and that helped cause the coming of the war. I think that's the reality that most of us would want to teach in our classrooms. I've listed another myth here. I think this is one that our students come into the classroom with. They somehow imagine that runaway slaves were chased by slave catchers from Georgia to Maine, that there was danger all across the country until they maybe got to Canada. Now, that's just not accurate. Now, of course, the Underground Railroad operatives and runaway slaves faced all kinds of challenges, but the grave dangers were in the South, in the slaveholding states. And if there's one thing I'm going to try to convince people of in this webinar today, it's that the the balance of power shifted north of the Mason-Dixon line, and that Underground Railroad operatives and runaway slaves uh, were not necessarily endangered in the North, and that when they were trapped or cornered, they often fought back quite effectively. And that's a key. The regional distinction is just fundamental and not well understood by our students. Now, the last thing I've listed here under myth is really more of a misunderstanding. So, as Richard mentioned, I'm a Lincoln scholar. There is a general impression that has developed that Abraham Lincoln was strong on the issue of containing slavery, but what you might say a soft on the issue of opposing the fugitive law. He supported the enforcement of the law. Most Republicans did, is how I think textbooks characterize it. That is, I think, a misunderstanding of his position, of their position. I would argue that the best way to understand this is to realize that the personal liberty controversies, the protection of free blacks and their personal liberty, was one of the gravest obstacles in the sectional crisis, and it's one of the last things they couldn't compromise over uh, during the secession crisis. And Lincoln was as tough on that issue as any Republican. Even Salmon Chase, who we're going to talk about today, who was called the Attorney General for the fugitive slaves. So I would, argue there's many other myths and realities to talk about. I'll try to cover as many of them as I can, but those are kind of the overriding myths and realities that we're going to try to cover over the course of this conversation. Now, I've broken this conversation up into two parts. So the first section I'm calling Toward Crisis. This is from the Constitution to the late 1840s, up until the making of the Compromise of 1850. And I've listed three takeaways here. I'm going to try to explain them as we go through a series of document excerpts or image excerpts. So the first is that there are multiple sets of laws here, both federal and state laws, when it comes to runaway slaves, and they collide. And the collision of those state and federal laws is the critical thing. You really have to be able to explain that to your students to appreciate the fugitive crisis. The next takeaway is that when we talk about the Underground Railroad, that's a metaphor. But what it refers to are vigilance committees. And I'm not sure that term is well understood at all. I don't think textbooks do a good job of explaining what a vigilance committee was. And if you get nothing else out of this conversation tonight, I hope that if this term is new to you, that you can understand, explain, and demonstrate what the vigilance committees were like during the years before the Civil War. And in this section of the conversation, I think we do want to try to explain why the 1840s marked a serious escalation of the crisis over fugitives. It happens at the same time that the territorial crisis is escalating in places like Texas or in the aftermath of the Mexican War in California. But the fugitive crisis is just as polarizing. Okay, so that's the big overview. I'd like to get right into it, and I think the place to begin is with the Constitution. You're looking at the Fugitive Slave Clause of the U.S. Constitution as it was written in 1787. I'm going to read it, and then I think we should try to discuss it. No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Okay, so I had two discussion questions there. What does that mean? And why is it so awkwardly phrased? So I wanted to start with the second one first, if you don't mind. This is something I think many of you talk about already in your class, but why is a clause like that so awkwardly phrased?
Okay, ladies and gentlemen, we have a question. Why is that so awkwardly phrased? Because lawyers wrote it, right? Okay, that's okay. Are they attempting to avoid the word slavery? First, it's awkwardly phrased because they didn't want to use the word slavery. Okay, and that is a glaring omission here
Yes.
at this point in our history. We have some other people writing in, so why don't we just wait a second to see what comes over the transom. But later on, we're going to get into some more legal writing that's even worse. Indentured service. Indentured service. Are they in the equation? That's a good question. And to obfuscate understanding, balance federal and state laws from Lee Holder. So we have, let's take a couple more here. Indentured servants, and let's see, we got one more coming in, so that there would be shades of gray as to who takes responsibility. Matt, how have we done?
Well, good. I mean, the most important thing, I think, is the one that everybody teaches already, which is that the framers did not put the word slavery into the Constitution. And you see that awkwardness in a number of clauses, the slave trade clause, the Three-Fifths Compromise clause, and this fugitive clause most notably. But there is something else going on here. And it's less so about indentured servitude and much more about the question of how this provision gets enforced. I think, as Jamie put it, the question of responsibility. Any good teacher should be able to point out that when a student or a writer slips into the passive voice, they're trying to avoid something. And so the question of shall be delivered up is one that elides or obfuscates responsibility. Who is doing the delivering? And this is a question of whether or not it should be state or federal agents who are responsible for making sure that runaways are delivered up. Now, I want to ask the group here, put yourself in a position of a constitutional scholar for a minute, or a lawyer. How does the placement of this clause in the Constitution affect your reading of responsibility?
Okay, how does it?
What does that mean to you?
Okay, placed in Article 4, and what does that mean to us? We have a couple of comments from the last question, Matt. Chanel writes, I think they wanted people to be able to find loopholes. I think they also wanted this law to apply to indentured servitude. Karen B. Asks who will pay for enforcement, so I think that gets back to the passive voice there, shall be delivered. But I'm no expert on the Constitution, but I think, doesn't Article 4 articulate the state's duties? Am I right in that?
Absolutely. Now, that's something that all of us should remember. We focus on Article 1 and the congressional power, Article 2, the executive, Article 3, the judiciary. But Article 4 is the section of the Constitution that deals with state responsibilities and relationships. And therefore, you might think that that means this was placed there for the purpose of defining the responsibilities of states. Now, it was placed there in late August 1787, at the urging of Pierce Butler, who was a delegate from South Carolina. And he has no interest in protecting the masters of indentured servants. He's focused exclusively on the masters who own slaves. But the introduction of this clause did not provoke a big debate. There was no outward discussion of the wording. There was a minor sort of editing process, but nothing that was controversial. And that is a reminder to us that at that time, most of the states still had slavery. There wasn't necessarily an expectation that there would be a great deal of contest over this, but there was at least the beginnings of a sense that there were some states that were moving to abolish slavery. And by this point in the summer of 1787, the Confederation Congress had just prohibited slavery in the Northwest Territory. And so that was part of what's driving Pierce Butler and the South Carolina delegation to insert this clause at the last minute in the Constitution. Now, it's going to turn out, this is going to be the seeds of some of the worst fighting, the worst political fighting in the years to come. But at that moment, they sense problems, they avoid some issues, but they don't realize the full weight of all of this. Now, I want to move on to the implementation of this clause, the fugitive slave laws. But before I do, does anybody want to raise a question or make a comment? Or Richard, is there anything that you have that you want to cover before we move to the next issue?
No, I think this Ginger Parks comment, I've never even considered the placement, such a fascinating way to look at it. I think that's true. I hadn't thought of the placement either. So I don't see any additional comments or questions coming across the wire. So why don't we move ahead, Matt?
Okay. So when the Congress began to write the fugitive slave law that the clause authorizes, the first federal law they write is in 1793. Now, the formal title of this law is an act respecting fugitives from justice and persons escaping from the service of their masters. Now, I will tell you something. I don't see this pointed out almost anywhere, in any textbook or in any classroom presentation. But one thing you should know as a teacher is that neither the 1793 Fugitive Slave Law nor the 1850 Fugitive Slave Law uses the word slavery. They follow the same circumlocution of the Constitution. They avoid the word slave or slavery. It's persons escaping from the service of their master. It's the same idea that guided them in 1787, that they don't want to write the principle of property in man into the federal Constitution, the federal law, or the federal code. And that's in deference to the anti-slavery sentiment that exists in the North, even as they're writing fugitive slave laws. So this is one part of that 1793 statute. It's the part that addresses penalties for those who help runaway slaves. So I'm going to read it. It's also awkwardly phrased, but I want you to think about what the meaning of this punishment is, and perhaps why or how it might surprise your students. So, be it further enacted, that any person who shall knowingly and willingly obstruct or hinder such claimant, his agent, or attorney, in so seizing or arresting such fugitive from labor, or shall rescue such fugitive from such claimant, his agent or attorney, when so arrested, pursuant to the authority herein given and declared, or shall harbor or conceal such person after notice that he or she was a fugitive from labor as aforesaid, shall, for either of the said offenses, forfeit and pay the sum of $500, which penalty may be recovered by and for the benefit of such claimant by action of debt in any court proper to try the same, saving moreover to the person claiming such labor or service his right of action for or on account of the said injuries or either of them. Now, that's a mouthful. I want you to think about that mouthful and explain what's surprising about the nature of that punishment? And as you're commenting on that or typing in answers, let me answer this comment about the fugitive slave laws. It says that we call them the fugitive slave laws, but they were not called that at the time. The truth is that in newspapers and in letters, they refer to them as fugitive slave laws, but the laws themselves, as written from Congress, just like in the Constitution, refused to use the word slave or slavery in deference to the anti-slavery forces in the Congress. So the question is, what is this punishment here, and what is the meaning of that punishment, and how might it seem surprising to you?
Mm-hmm. So, Lee Holder, to be honest, while I always teach the stricter fugitive slave law, I have never taught the students what the previous 1790 law actually stated. The punishment is a large sum of money, $500. $500 fine was a lot of money back in those days. How much would that be today? That's true. That is a lot of money back in the 18th century. We have some other comments coming in. But this strikes me as almost a parody of legal writing. It's it's unbelievably complex. I don't know why lawyers have to do that. But the $500 penalty, Matt, is that the kind of penalty that's really going to sting? And also, was it enforced? That was the question I would raise.
Yeah, no, those are two very important issues. So $500 in theory is an awful lot of money. We could calculate it using various historical rate calculators, but let's just all stipulate it's a lot of money. Unfortunately, though, for the slaveholders, and I say that with tongue in cheek, it was hardly ever enforced, and that is the problem as far as they were concerned. You can hardly find cases where that fine was applied. But even so, what I think is most surprising to my students is that these are civil penalties. Mm-hmm. This is a civil statute. These are not criminal penalties. And you might imagine a fugitive slave system, one that punishes operatives who are helping runaways escape, would be geared toward putting people in jail. But that was not how the 1793 statute was organized. And the meaning of that, I think, is pretty powerful. Because what it forces you to remind your students is that there were hardly any federal crimes back then. Criminal law was state law. And so the criminalization of the fugitive process is left to the states. This is how we have to teach this issue. It's not just about two federal fugitive slave laws. It's about the state laws that grew up between 1793 and 1849. Now, these state laws took decidedly different turns. In the South, they passed criminal statutes that punished people for helping runaway slaves, and they called them slave-stealing statutes. And some of those punishments could be quite harsh. But in the North, as northern states abolished slavery, they moved in the opposite direction. They moved toward punishing people who kidnapped free blacks. A number of states passed what they called personal liberty statutes or anti-kidnapping laws that punished slave catchers as kidnappers if they seized free black residents by mistake or by intention. And so this is the conflict of state laws that begins to create a sense of crisis among Southern slaveholders in the 1830s and 40s as they worry that their rights as slaveholders are not being protected under this, what they consider to be dead letter 1793 law. Now, I saw a couple of questions come in over the chat, Richard. Let me pause. Are there issues I need to address now?
Sure, yeah. Well, first of all, Ginger Park, let me see, that's gone beyond me there. Ginger notes that today $500 would be worth $12,195.12, so that's a pretty steep fine. Just for clarification, Chanel asked, is this also Article 4 of the Constitution? No, this is a separate federal piece of legislation, right?
Right, we're now in the federal code.
Okay, so this is not part of the Constitution. One of the questions came through here, who would collect this fine?
So it says any court proper. In practical terms, this was left to state courts, local and state courts, to prosecute. There was a fine, and in some states they added costs, which could include the costs of the slave. So in a few cases, people paid more than this, but in most cases, there was no enforcement of this section.
No enforcement. And Mary writes, how does the fine compare with the average range of cost for a slave?
Well, slave valuations fluctuate greatly between 1793 and 1849, so we'd have to pinpoint time and place to get a good answer to that question.
And here we have a question that I think we're going to be getting to later on. Pat Marshall writes, were there local as well as federal fugitive slave laws? If so, how did local regional laws compare to the federal mandates? And then Judy Batten raises a question about personal liberty laws, which we're going to get to. And then Ginger writes, Mary, slave prices depended on age, sex, and job the slave did, but a male slave 25 years old was a good $500 to $800 investment, from what I remember from the primary sources I've seen. Okay, let's go back to that question about local fugitive slave laws. Do you want to defer that, Matt, or do you want to address that now?
No, I feel like I just covered that, so let me just repeat what I said and make sure it's clear, and if it's not, then people should ask me questions. After 1793, southern states passed slave-stealing statutes. Mm-hmm. Those were their fugitive slave laws, which punished people for helping runaways escape. In the North, they moved in the other direction. They passed personal liberty statutes as early as the 1820s that began to protect free black residents from kidnapping. There were other types of laws that sometimes addressed these issues, or sometimes basic criminal laws were applied. But those are the two basic categories of state laws that matter: personal liberty statutes in the North and slave-stealing statutes in the South. Now, I don't think most textbooks cover this. And I think most people are more inclined to focus, as someone said earlier, on simply the 1850 law, the federal law that is passed in the aftermath of this collision of state and federal laws. So I think in order to really appreciate what the Compromise of 1850 is about, you're going to have to start to explain this collision. I think we can get some depth to it by focusing on a few other events. And so I'm going to highlight one Supreme Court case for you. Prigg versus Pennsylvania. Now, I know everybody is limited in the amount of time and depth they can go into, but Prigg versus Pennsylvania is one of the most important Supreme Court cases, in some ways more relevant than the Dred Scott case. I know the Dred Scott case is more important and certainly better known, but Prigg versus Pennsylvania was the first Supreme Court review of the constitutionality of the 1793 statute. It was a case involving a slave catcher named Edward Prigg, who was accused of violating the Pennsylvania personal liberty law, a law that was adopted in 1826. He had come into York County, Pennsylvania, and seized a woman named Margaret Morgan and her children, and brought her back into slavery. Then the Pennsylvania legislature and the governor requested extradition of Prigg from Maryland, and eventually, as part of an arrangement to test the constitutionality of this law, Prigg went back to Pennsylvania and was convicted of violating the Pennsylvania anti-kidnapping statute, the personal liberty law. The case was appealed all the way to the Supreme Court, and the Supreme Court ruled that the Pennsylvania law was unconstitutional. It threw out the personal liberty statute, and in doing so, the justice who wrote that opinion, Joseph Story, he's almost as important as John Marshall, a leading nationalist from New England, but he writes what's essentially a pro-slavery opinion. He says the Fugitive Slave Clause was one of the central compromises of 1787, and the Fugitive Slave Statute enforces it, and no state can interfere with it. But he acknowledges in the decision that the responsibility for delivering up those fugitives is a federal one. Even though it was in Article 4, he says in this decision that it's a national responsibility. And the quotation I have here from his opinion, which you can get full text online, is, if there are not now agencies enough to make the assertion of the right to fugitives convenient to their owners, Congress can multiply them. But if it should not be done, better it is that the inconvenience should be borne than that the states should be brought into collision upon this subject, as they have been, and that they should attempt to supply deficiencies upon their separate views of what the remedies should be to recover fugitive slaves within their jurisdiction. Now, this is a leading nationalist on the Supreme Court writing a pivotal landmark decision where he says there's been a collision over interpretations of fugitive slave laws between the states, and the government in Washington has to settle it. And if Congress doesn't have the agencies to enforce the law, they have to create them. Now, that is a turning point. It's a turning point in a bunch of different ways. But one of the ways it's a turning point is that it ignores the belief in the North that free black residents deserved personal liberty protections. Maybe not civil rights, maybe not equality, but that they should be protected from kidnapping. And in the dissenting opinion to this case by Justice John McLean of Ohio, he says the slave, Margaret Morgan, is found in a state where every man, black or white, is presumed to be free, and this state, to preserve the peace of its citizens and its soil and jurisdiction from acts of violence, has prohibited the forcible abduction of persons of color. This becomes the battle royal that's going to escalate over the next 15 years and lead to the Civil War. Do northern states have the rights to protect their residents from kidnappers? Or does the slaveholding right, protected by the Fugitive Slave Clause, override it all? It's Southern federal power versus Northern states' rights.
I have an interesting comment here from one of our participants who is shedding some light on the absence of the word slavery in the Constitution and in the fugitive slave laws. Ken writes, the writing of the law has to be very precise. The word slave can be interpreted differently. For example, women were slaves to their husbands. Women were seen as property at that time as well. Wording of the law cannot be ambiguous. So, was the omission of the word slavery an attempt to be precise, or was it obfuscation?
I understand the point that Ken is making, but I do disagree with it. In this case, it's a battle between pro-slavery delegates to the Constitution and anti-slavery delegates to the Constitution over whether or not to put the word into the document. Anti-slavery forces wanted to keep the word out because they thought by keeping the word out, they'd keep the principle out. They'd make slavery local. Now, not everybody has to agree with me, and Ken can teach it differently, but the way I teach it is cast in a different fashion.
Mm-hmm. And Greg writes that it's interesting that Justice Story is connected to the Amistad case, and he wrote this opinion. Meredith writes, it's fascinating that McLean is willing to mention race as a divisive issue rather than their status as property or their servitude status like the other laws we've seen. Would you comment on that, Matt? Is this a distinctive decision in that it does raise the issue of race quite explicitly?
Yeah, in fact, I think Meredith is focusing on what's so powerful about this, which is that there are some people, led by Justice McLean here, who believe that northern states have the right to protect black people. That's why these personal liberty statutes represent such a challenge to the federal fugitive slave law. The federal fugitive slave law, the clause, the whole attitude of pro-slavery forces is that free black people have no rights. They have no rights any more than slaves have rights. But McLean and anti-slavery forces in the North are increasingly saying, even though slaveholders have rights, free black people have rights too. And we're not going to give away these free black personal liberty protections just because slaveholders want it easier to recover their lost property. And that is almost an irreconcilable difference that's going to escalate very quickly. Mm-hmm. Does anybody else have a question or want to comment about that?
Okay, we have another comment here. Can you make this issue a bit more realistic in terms of actual experience of fugitive slaves like Douglass, William Wells Brown, Henry Box Brown, and others? So we're going to come to Henry Box Brown. Do you want to defer that question, or do you want to address it now? Well, speak of Frederick. There he is.
Let's talk about Frederick Douglass in this context. So here's how I would teach Frederick Douglass and the rise of the Metaphor Underground Railroad. It actually bursts onto the national scene right in the aftermath of Prigg, which was a decision from 1842. Douglass had escaped from slavery in 1838, leaving Baltimore, passing through New York and eventually ending up in New England before he relocated to Rochester. He published his narrative in 1845, and in his narrative, he describes his reaction to the Underground Railroad. And I find this to be one of the most revealing passages of all, and I teach it in the shadow of the Prigg decision. So I'm going to read this excerpt. I have never approved of the very public manner in which some of our Western friends have conducted what they call the Underground Railroad, but which I think, by their open declarations, has been made most emphatically the Upper Ground Railroad. I say, let him be placed in this most trying situation, the situation in which I was placed, and then, and not till then, will he fully appreciate the hardships of, and know how to sympathize with, the toil-worn and whip-scarred fugitive slave. Thank heaven, I remained but a short time in this distressed situation. I was relieved from it by the humane hand of Mr. David Ruggles, whose vigilance, kindness, and perseverance I shall never forget. Now, I actually think this passage is kind of like a decoder ring to understanding the Underground Railroad. So, in my discussion questions, I wanted to press your background knowledge on some of this. When he says Western friends, and he's complaining about their open declarations, who is he referring to here?
Okay. Who is Frederick Douglass referring to when he refers to his Western friends? Now, this would not be, of course, the West as we think of it. It would be more like what we would call the Midwest, right? Isn't that what he's talking about here, Matt? What we call the Midwest today?
Absolutely. So he's talking about abolitionists in places like Ohio,
Okay.
or Illinois, in Chicago, in Michigan, in the Northwest territories that are now entering the Unionist states, where there's a high degree of New England diaspora and a strong abolitionist anti-slavery movement, and a number of anti-slavery newspapers that in the aftermath of the Prigg decision are pushing a number of tactics designed to provoke confrontation with the slaveholders and slave catchers. So this is where the phrase Underground Railroad first appears, in Chicago anti-slavery newspapers and elsewhere in the Midwest. This is where you begin to see a political campaign to rewrite Northern personal liberty laws. They rewrite the laws in states like Massachusetts and Pennsylvania and elsewhere in the 1840s to meet the test that Story laid out in Prigg, but to reimpose their view. They take state officials and state courts completely out of the fugitive system and say that if Story's position is the new ruling, then the federal government has to enforce the law. States don't have to be involved at all. And in the aftermath of Prigg, you see widespread growth of what they call vigilance committees, led by men like David Ruggles. Now, I'm just curious, how many people have heard of David Ruggles or teach him today? He's a very pivotal figure.
Okay, how many people have heard? And we have a response to your earlier question. Pearlie writes, Douglass might be referring to abolitionists whom he disagreed with, and that probably abolitionists in, as you said, Ohio, Illinois, probably Western Pennsylvania, what we now would deem the Midwest. So let's see, we're getting, I don't quite know what I've never heard of David Ruggles, and we've got lots of exclamation points there. Read about him in a passage about antebellum New York. Never heard of Ruggles either. I think it's safe to say, Matt, that Ruggles is a new person on the horizon for us.
So David Ruggles, you might call the founder of the vigilance movement. He organizes the first vigilance committee in New York City in 1835. He's a free black man born in Connecticut who's a bookseller and a printer, radical, militant. And the vigilance committee he creates in New York City in 1835 is designed to protect free blacks from kidnapping. It's a lobbying effort, a self-protection society. Vigilance is a 19th century term that refers to self-protection when there's no state or police force that can offer you protection. So free blacks had to organize themselves, and David Ruggles leads them. But right away, David Ruggles suggests that vigilance is going to apply to runaway slaves as well, that anyone who comes to their doorstep deserves their protection. And they start to help both runaway slaves and free blacks. And they do more. They publicize their work. They have annual reports describing and bragging about what they've done. It's totally out in the open. It's quite defiant. And it is, part of this sectional effort to polarize and publicize the battle over slaves. Now, Douglass is criticizing some of the Western abolitionists for being too open. But what he does here in 1845 is a kind of coded way to refer to the help he received from the New York Vigilance Committee. In his narrative, if you go back and reread it, he makes it seem as if David Ruggles just stumbled upon him when he was hiding in New York, and by chance, they encountered each other, and Ruggles saved him. And he's so thankful for him. I shall never forget, he says. But look at what he shall never forget. His vigilance, kindness, and perseverance. The word vigilance is the kind of word that we could pass over. Our students would certainly pass over today. But it's a coded word. It's a reference to the Vigilance Committee. And so when we teach this narrative, especially this passage, we should understand that Douglass is warning some abolitionists from being too open in this post-Prigg era, but he's also acknowledging in some ways how open he's been and how valuable the vigilance effort in New York has been, at least in his behalf.
So Matt, we have a question. Kelly writes, was Ruggles like William Still? We might want to define who William Still is, and note that William Still appears in the lesson that we prepared on the Underground Railroad. But to get back to that question, was he like William Still, Matt?
William Still would later be the head of the Philadelphia Vigilance Committee. We'll talk about him, and I'll show you a picture of him in just a minute.
Okay, and then we have another question. Where was Solomon Northup at this time? He was captured and taken back into slavery, though a free man.
Solomon Northup's case is one that demonstrates, the power of the kidnapping movement. This is going to occur later, and his narrative will be published in the 1850s and, will transfix, northern audiences. But it's a demonstration of the fear of kidnapping and the value of vigilance and personal liberty. I did ask one question here that I want to highlight for you. How should we define the Underground Railroad is one of my discussion questions. I always do this with my students. I find it very revealing. When I ask them to define the Underground Railroad, they almost always refer to a network of safe houses. I see this language commonly on websites and in textbooks. But what I drive home for them is that it's not safe houses that rescue people. It's a network of committees, of these vigilance committees, and other groups organized and in correspondence with each other that form the basis of the Underground Railroad. The term itself, and this is something I also think we should emphasize, the term itself is a metaphor. I mean, it's not an institutional affiliation. It's not a label. It's a metaphor that describes something else. And in this case, it's describing the overlapping networks of people, usually organized in committees, often called vigilance committees, that existed across the North and sometimes in parts of the South to help runaways escape. And in their work, which was usually quite open and defiant, at least in the North, it was pivotal for polarizing the sectional crisis and bringing the nation closer toward war.
Mm-hmm. And that's remarkable because it did not really bring to freedom that many slaves, did it? I mean, what's the estimate of slaves who found freedom through the Underground Railroad?
Well, the estimates vary, but usually relying on the census records, people suggest there might be 1,000 slaves a year who escaped to permanent freedom. Estimates we have using plantation records suggest on an average year about 100,000 slaves would escape temporarily, what they called laying out. But these estimates are very shaky. My point is that the numbers of slaves who escaped via whatever the Underground Railroad was is less important than the number of stories about what they were doing. The press coverage of the Underground Railroad was overwhelming. The intensity of the plays and novels and stories and poems and songs and newspaper articles and speeches. That was what the Underground Railroad was really about. In that sense, it was an upperground railroad. It was about trying to polarize opinion on this question of the injustice of slavery by using runaways to help do so.
So
this is cutting against the tradition of the secret Underground Railroad. And not everybody is going to see it the way I do, and not every scholar emphasizes this as much as I do. But I'm showing you a series of excerpts from real documents. And if you disagree with me, you have to look at a comment like the one Douglas made in 1845 about the Upperground Railroad and try to explain it. It's not impossible, but it's challenging.
And we have a question here. Does Harriet Tubman fall under the parameters of this definition you're providing?
Yeah. Harriet Tubman works for the Philadelphia Vigilance Committee. And in the lesson and in some of the documents I'm about to show you, I'll demonstrate how we can chart her progress as an operative through the records of the Vigilance Committee.
And Jamie writes, I would like to know about some of the songs. I guess she's referring to the songs that were supposedly sung to warn people or to alert slaves that the Underground Railroad was available, people were making a move. Is that true? I mean, were there songs like that that were used as signals to slaves in the South?
So, almost all of the songs, like the Drinking Gourd and other traditions, are more folklore than reality. The songs themselves, the idea of them containing codes, you can't document that with contemporary evidence. The closest you can come to the use of songs as a tool for escape is that there are some accounts that place someone like Harriet Tubman as using tempo in songs to indicate urgency in a few cases. But it's not something that was universal. By the way, the same myth holds true for quilts. There is no contemporary record of quilts being used to contain codes. Almost all of that is folklore that actually, in the case of quilts, comes late into the 20th century and wasn't even found in 19th century folklore. The one thing that they did do with quilts, and this fits with the way I'm describing the Underground Railroad, is that they sold them at fundraisers to raise money for their vigilance efforts. And so they would openly sell quilts as a way to raise money to help slaves escape, and they would publicize all of this in the North. And that's, I think, just an important distinction that is hard for some people to accept, but I'll try to convince you with evidence.
Okay,
I do want to show this slide before we discuss it further, though, Richard, because I feel like this will help make sense of it all. You're looking at a picture here called The Branded Hand. It's a picture that captures a punishment that was meted out to an Underground Railroad operative. His name was Jonathan Walker. He was a sea captain. He was arrested in Florida in 1844 for allegedly trying to help 7 slaves escape to the Bahamas. At the time, Florida was a territory. He was prosecuted in territorial court and convicted and sentenced to be humiliated in a public pillory and then branded slave stealer on his hand, as well as chained and locked into a darkened cell. Eventually, abolitionists paid for his fines and he was released, and in 1845 he becomes an abolitionist orator. John Greenleaf Whittier writes a poem about him. They took a photograph of his hand and made illustrations of it. It was reproduced in newspapers like the Anti-Slavery Bugle. He becomes a martyr for the abolitionist movement. Now, I ask here, why were abolitionists so determined to use this image and the story of Jonathan Walker as sectional propaganda? I want to pause here, and I want you to think about that for a second. I just got done saying that they were quite open about their fight in the North, but now I'm suggesting that there were these punishments meted out to operatives in the South that were quite barbaric, like this one to Jonathan Walker. So why would abolitionists be so determined to focus attention on that kind of barbaric punishment?
Okay. Why would they be so determined to focus attention on the kind of punishment handed out to slave stealers and Underground Railroad operatives in the South. Um, in the meantime, we have a question here about the term vigilance. Um, did you say vigilance was the term committees used, and if so, why that choice?
Vigilance is an all-purpose 19th century term. It means self-protection.
Mm-hmm.
And so black people began to organize self-protection leagues and committees, and they often called them vigilance committees. Sometimes they used other names. John Brown organized a vigilance committee. He called it a League of Gileadites. In Cleveland, they called themselves the Committee of Nine. Sometimes in Harrisburg or in other cities, they called themselves a Fugitive Aid Society. But they were all different types of vigilance committees. The point here is that in the 19th century, when people are trying to operate, they form committees, and they usually keep records.
Okay, and in response to our question about why the branding, why the abolitionists used it, they wanted to use it as a fundraising tool, as Lee says, raise money in the North and in Europe, try to discourage others from, well, the Southerners tried to discourage others from participating in abolition. The extension of the fact that slavery was the ultimate barbarity, to get people to come to their side, humanize the punishment, evoke feelings, to show Southerners' disregard for all people, not just slaves. Maybe the abolitionists wanted to make more public how barbaric the slaves owners were. Not only were they brutal to slaves, but they were also brutal to those who helped the slaves. And let's see. Yeah, I think those pretty well. And here, to make people realize the South is willing to humiliate people that are willing to challenge the institution of slavery. And then Chanel writes, it's another polarizing tactic on the part of the abolitionists. They also looked at the religious angle of slavery and its injustice. Okay, so the Northern abolitionists got a lot of what we would call today public relations mileage out of displaying that brand. Is that fair to say?
Sure. I think all of those answers have elements of truth and meaning to them. You put it all together, and it's painting a sharp contrast between a slave society that not only humiliates and degrades black people, but humiliates and degrades white people. Mm-hmm. And oppresses freedom, not just for black people, but for white people, and does so in barbaric ways that show how barbaric and backwards slavery was, and how forward-looking a liberal free labor North was in the position or from the perspective of the abolitionists. 1844 was a pivotal year for those kind of punishments. Southerners were determined to punish operatives that they captured in the South. So Jonathan Walker got branded. Charles Torrey was an abolitionist who got captured in Washington, helping slaves escape. He was sentenced to 6 years in the Maryland Penitentiary. There was an abolitionist named Calvin Fairbank who was captured with a woman named Delia Webster in Kentucky. She became the first white woman sent to prison as an Underground Railroad operative. And he, Calvin Fairbank, was sentenced to 15 years. His sentence was commuted after a few years, and then he was convicted again of helping slaves escape. And so ultimately, he served 17 years in prison in Kentucky for helping runaways escape. He claimed during that time he was whipped 35,000 times. Now, that's the stark difference between North and South. Those were the kind of horrible punishments and tortures that were inflicted on Southern operatives, and which is why the Underground Railroad was truly underground in the South. There is no comparison you can make to punishments in the North. I cannot identify a Northern Underground Railroad operative who suffered from that kind of legal punishment, helping slaves escape north of the Mason-Dixon line.
Mm-hmm. Now, we have a little over half an hour left, and I think we should move on, but we have one question here that's really interesting. Ken writes, why the hand? Why not tattoo somebody on the chest, the arm, the leg, the shoulder? Why the hand?
It's a good question, but I don't have a good answer to that. I can speculate, but the truth is I don't know.
Okay, well, Karen speculates maybe it was because the hand is hard to hide. So, and that's a pretty good speculation there, it seems to me. Well, shall we move ahead then?
All right. So now here's Henry Brown. Several people have mentioned him already. You're looking at an image of a slave who escaped in a box that was shipped from Richmond to Philadelphia in March of 1849. This is a story that very quickly became the most sensational Underground Railroad escape of the era. Brown was distraught in 1849 because his wife was owned by a different master, and she and his children were sold away from him. And so he worked with a group of operatives in Richmond who then reached out to the Philadelphia Vigilance Committee. A man named Samuel Smith came to Philadelphia and met with James McKim, who was basically the William Lloyd Garrison of Pennsylvania. He's the man holding the hatchet in this image next to the box. And they arranged for this escape. And Henry Brown escaped. It took him about 24 hours in this box. William Still, who's holding the lid to the box, is the black man who's the leader of the Underground Railroad in Philadelphia, the head of the Vigilance Committee. And within weeks after the escape, the story is made public across the North. It creates a sensation. None of the men in this picture who helped Brown escape faced any legal repercussions for their work. None of them were hauled before the authorities. The only people who came to harass them were agents of the shipping company, the Adams Express Company, who warned McKim that if they did this again, they would lose their shipping privileges. But Samuel Smith, the white man who helped Henry Brown escape from Richmond, he was captured after they tortured witnesses, and he eventually spent 7.5 years in Virginia Penitentiary. And so you can see that's a classic example of the difference between North and South. But the other factor here that I think makes this a powerful gateway for understanding the nature of the Underground Railroad is that this is the ultimate symbol of the escalating crisis. This is March of 1849. By the summer of 1849, this news was everywhere. That's the precursor to the Compromise of 1850. It's not just about the California gold rush. It's also about the crisis over fugitives and the push to get a tougher fugitive slave law. So I want to keep going, but I'll pause here for a second. I imagine a lot of people teach this story. Does anybody want to ask a question or make a comment about the Brown story? I want to make sure that people feel like they have the information and resources they need to teach it. And I will have references to web material after this class that you can use as extensions. We've done some remarkable things with this story, including create a Google Earth tour that recreates the escape.
Okay, any questions about Henry Box Brown and how you might, how do you use it in your classes if you do? We had a number of people respond to the question about why the hand, and basically they're all on the theme of you can't hide a hand, and people have said that if it's the right hand, that's the hand with which that's the hand you present when you shake hands, and it would always, that brand would always be there and be a sign of shame. But maybe in the North it wouldn't be a sign of shame. So let's see what else we have. Curious that Brown looks like a gentleman, not a harried slave. This is a very effective story. Kelly writes, the students got really into the story, read a trade book about Henry Brown to second graders. I could see that would appeal to second graders. Little said about him after he arrived in Philadelphia, what was life for him in freedom. Can we cover that quickly, Matt? How did he fare when he got to freedom?
It's a fascinating but complicated story. Bottom line is he relocated to England because they were worried about his celebrity attracting slave catchers. While he was there, he became a celebrity. He was Professor Henry Brown. He would jump out of a box on stage and perform a show for anti-slavery audiences. But this is hard to convey in a classroom at the elementary or middle school level, but I talk about it in my college classroom. He remarried a white English woman, and one of the black men who worked with him accused him of betraying Nancy Brown, his wife, who had been sold into the Deep South. We don't know what how Henry defended himself from this charge because we only have one side of the story. But to me, it's a good example of how even though these people are heroic and this is Hollywood-level drama, they're still human, and they were engaged in all kinds of the usual human conflicts. We don't actually know when Henry died or what ultimately happened to him. He came back to the United States, but then he disappears from the public record.
Mm-hmm. And then we have one final question about Henry. The story is so miraculous. What documentation is there to really verify its authenticity?
Yeah, well, that's what's so remarkable about this story. This is one of the best documented Underground Railroad escapes. So within days after he arrived in Philadelphia, William Still wrote a letter to the head of the New York Vigilance Committee describing the details. And then the head of the New York Vigilance Committee wrote letters about it. And then within weeks, there are newspaper stories about it. And Henry Brown actually wrote two narratives, one through a ghostwriter and one allegedly by himself. But the point is that you could document this story as well as almost any other escape of the era.
Mhm.
All right. Now,
Okay.
this is all precursor to the political crisis of the 1850s. This is the second section of our discussion today, and I have a few takeaways to highlight for you at the beginning of it. What's going to happen after the crisis of the 1840s is they pass this new, tougher 1850 statute, but it does practically nothing to contain the crisis. I think that's a hard point for some people to accept, but I'll try to explain why I think it's true. And then here is where in the 1850s, the documents and the records are just rich and accessible. All of the Vigilance Committee records that we have, almost all of them, are from the 1850s, and they're really teachable. And then finally, I'm going to try to get to a discussion of how secession, in many ways, was fueled in part by the battle to protect the personal liberty of free blacks. And I think that's a really useful way to teach it. Now, here's a section from the 1850 law. Now, this is a law that was passed as part of the Compromise of 1850. Basically, most of the new law created U.S. Circuit Court commissioners, the kind of agencies that Joseph Story said Congress would have to create to implement the federal law. So these are new federal court officers empowered to hear cases involving fugitives. It takes the enforcement of the law out of the hands of state officials. And then it offers much tougher punishments for people who resist or interfere with the process of tracking down and returning these fugitives. Here's Section 7. This is the punishment section for those who are Underground Railroad operatives. Be it further enacted that any person who shall knowingly and willingly obstruct, hinder, or prevent such claimant, his agent or attorney, or any person or persons lawfully assisting him, her, or them from arresting such a fugitive from service or labor, either with or without process, as aforesaid, or shall rescue or attempt to rescue such fugitive from service or labor, or shall harbor or conceal such fugitive, so as to prevent the discovery and arrest of such person after notice or knowledge of the fact that such a person was a fugitive from service or labor as aforesaid, shall for either of said offenses be subject to a fine not exceeding $1,000 and imprisonment not exceeding 6 months by indictment and conviction before the District Court of the United States for the district in which the offense may have been committed, or before the proper court of criminal jurisdiction, if committed within any one of the organized territories of the United States. And moreover shall forfeit and pay by way of civil damages to the party injured by such illegal conduct the sum of $1,000 for each fugitive so lost as aforesaid, to be recovered by action of debt in any of the district or territorial courts wherein the offense may have been committed. So I'll short circuit this discussion just a little bit, just to make sure we have enough time. Someone just typed in that they lost sound. Just let me pause here. Richard, can you hear me?
Yes, I can hear you. This happens from time to time. If it doesn't come back, Val, well, she can't hear me. Let me send Val an email, a little chat here, and we'll hope that will take care of it. But let's proceed.
Okay. So I asked in my discussion question, does the revised code sound draconian? Or is it draconian? Might be a more accurate way to put it. So what you have here is an increased fine from $500 to $1,000. They're also liable for costs that could be recovered as debt, but now potential prison sentence of up to 6 months. The punishments have been dramatically increased, but the key question is, were they enforced? And that's something that often gets lost in translation. The Section 7 that I just read, that draconian series of punishments was almost never inflicted on anybody from 1850 until the law was repealed in 1864. I can only identify a handful of people who were imprisoned briefly for helping runaway slaves in the North in the 1850s, and just a handful more who were fined. Now, those fines were damaging, certainly, but the impression my students have is that once this law was passed, anybody who helped a runaway slave was thrown into jail or tortured, that Underground Railroad operatives were, hiding and running for their lives, that blacks in the North were relocating to Canada in overwhelming numbers. But the story that I think is more powerful and more accurate is that there was still an overwhelming resistance to this law in the North, even after these punishments were laid out. I'm going to give you a set of numbers now. I think these are worth thinking about. From 1850 to 1861, the coming of the Civil War, right now, we can only identify about 350 cases of fugitive slaves being captured and introduced to the rendition process. Out of those 350 cases, about 100 of them were what we call recaption or kidnapping episodes without a hearing. About 250 of these cases involved hearings. So 250 individuals had a hearing under this law during those 11 years. That's about 125 hearings over a decade across the entire country under this law. And they were almost exclusively in 5 states. 90% of those hearings occurred in 5 states, the border states in the North: Illinois, Indiana, Ohio, Pennsylvania, and New York. That's not the kind of numbers that my students expect when they hear about this law. It's not the kind of draconian police state that they imagine. After 1854, there are no fugitive slave hearings in New England. There are no fugitive slaves returned from the Northeast. 75% of the cases after 1854 occur in the state of Ohio because the federal government is trying to pound Salmon Chase, the fugitive slaves attorney, who's now the governor of Ohio. The law, from the perspective of white Southerners, is practically a dead letter almost from the beginning. They don't think it's being enforced, and they're furious about it because they expected so much from the revised code. Now, I'm going to show this with another slide here. This is a letter from a slave catcher to a slave holder in August of 1851. This is a very rare document. It's a secret letter from the slave catching side of the equation. After the 1850 statute, William Paget, the slave catcher, writes to the slaveholder Edward Gorsuch, "I have the required information of the 4 men, that is the runaways, that is within 2 miles of each other. Now the best is for you to come as a hunter disguised, about 2 days ahead of your son, and let him come by way of Philadelphia, and get the deputy marshal, John Nagel, I think is his name. Tell him the situation, and he can get the force of the right kind." And then he goes on to describe the logistics of how they can meet up and defeat and catch these runaways. But when I show this document to students, I ask them to describe who's in danger here. And, the takeaway is that this letter reveals that slave catchers felt in jeopardy and in danger once they crossed the Mason-Dixon line in Pennsylvania. They had to come as hunters disguised, even after the 1850 law. And in fact, Edward Gorsuch got killed in Christiana, Pennsylvania in September of 1851, trying to recapture his 4 runaways at what they call the Christiana Riot. In that first year after the fugitive slave law was passed, 75 Northerners were accused of trying to violate this law with violent resistance in places like Boston during the Shadrach Rescue, or Christiana in Pennsylvania, or at the Jerry Rescue in New York. And out of those 75 people, not a single one of them spent any significant time in jail. Only one of them was convicted, and he was appealing his conviction, and it wasn't for violating the 1850 statute, and he probably would have won that appeal, but he died before it could be reached. Everybody who was involved in the death of Edward Gorsuch at Christiana was released. Not a single abolitionist or black vigilance member went to jail. There was widespread jury nullification, you might call it, in the North after this. a resistance to enforcing federal law against their states' rights. It's not like they were all anti-slavery or egalitarian in the North, but they were states' rights advocates too in their own way. You can see, I think, the pattern here. I want to pause, Richard. I'm moving fast because we're running light on time, but do people want to ask questions or make comments?
Okay, we have a question about the fine about under the 1850 Act. Would the punishment be per slave they helped, or like a flat fine punishment?
So it could be a fine per slave, and then they could also be liable for costs. It was applied in different ways.
Mhm. Okay, and you've been talking about the danger to the operatives. What about the slaves themselves? I mean, um, if the operatives were caught in the North, they weren't prosecuted. But how dangerous was this for the slaves? Now, clearly, it's dangerous moving through the South. How dangerous was it for them when they got into the North?
Well, we have a record of one runaway slave who was killed in Pennsylvania in 1852. But other than that, we have these 350 cases over these 11 years. And out of those 350 cases, none of those people were killed, but close to 85 or 90% of them were remanded back to the South,
Oh,
re-enslaved.
I see. So it was quite dangerous.
Well, it was quite dangerous if you were captured, but that 350 number represents a fraction of the number of runaways who made it safely. So from 1855 to 1861, we have 85 cases that we can discuss prosecuted under the fugitive law. But I can point to records from the Vigilance Committee showing that there were several hundred documented escapes that were successful during that same period. So far more success escaping in the North than being recaptured and remanded back into slavery.
And how far south did the Underground Railroad operate? Now I know it operated in the border states, but did it really operate in the deep South? Was it effective in Alabama, Georgia, Mississippi, Louisiana?
Well, the vast majority of people who escaped into the North came from the border states.
Hmm.
There were Underground Railroad operatives across the South, but it's exceedingly dangerous. And so you're far more likely to see them in urban areas or in the border areas. But even there, in cities like Richmond or Washington or Baltimore, it could be quite dangerous.
Right. And what about the coast? Coast? Was there an Underground Railroad route, if you can call it that, that took the ocean
Of
or
course, but
waterways?
it all depends on how broadly you want to use the term Underground Railroad. If you want to
Right.
apply it to anybody who helped a slave escape, there are escapes to the south and to the west and by water. They're not part of the Vigilance Network. They're not part of the Northern Underground Railroad, but they're nonetheless, you could apply the Underground Railroad terminology to them. That it's not a terminology they use themselves.
Hmm.
Now, the Philadelphia Vigilance records are examples of the Vigilance Committee records that we can read right now online. And the lesson plan that you have is going to use some of these records. These are records that document people like Harriet Tubman. So you're looking here now at an actual operational letter from an operative in Delaware, which was a slave state, to the head of the Philadelphia Vigilance Committee, James McKim, in December of 1854. He says, "We made arrangements last night and sent away Harriet Tubman with 6 men and 1 woman to Allen Agnew's to be forwarded across the country. Harriet and one of the men had worn their shoes off their feet. I gave them $2 to help them fit it out and directed a carriage to be hired at my expense to take them out, but did not yet know the expense." He goes on and continues to describe what's going to happen next. That's an operational letter, a document that we have that you could show your students that talks about an escape that Harriet made Christmas time from Maryland with some of her brothers, and she successfully passed them through from Philadelphia to New York to Canada. We can document every part, every leg of that journey, and it's quite remarkable. And you can tell why they're keeping records here. Part of the reason for this letter is because Thomas Garrett wants to be reimbursed for buying her new shoes. Any teacher in America can appreciate this. This is a request for reimbursement to the Philadelphia Vigilance Committee. And here's an example of a New York vigilance record. Some of you may have heard Eric Foner just wrote a new book called Gateway to Freedom, which is about the Underground Railroad in New York and the New York vigilance operation, and in particular the leadership of a white journalist named Sidney Howard Gay. Right around the same time in his records, which you can read in their original online from Columbia University, he describes Harriet Tubman, who he calls Captain Harriet Tubman, arriving with a party of 4 from Philadelphia in May of 1855. Harriet Tubman 7 years ago was the slave of Edward Broadhurst of Bucktown, her master dying, the estate to be settled, and 2 of her sisters having been sold into a chain gang. She determined to run away. She did so and made her way to Canada. In a few months, however, she concluded to return. She went back and sought concealment in the house of a friend who first advised her to escape. She made her arrival known to friends and her purpose, which was to lead them out of Egypt. This is why Harriet Tubman is important. She was one of the few operatives who went back and forth across the Mason-Dixon line. That's incredibly dangerous. And yet that's why she gained so much respect. Gay calls her captain. John Brown called her general. All of them in the movement knew who she was, even though the slaveholders didn't know her by name. And so, teaching Harriet Tubman makes an awful lot of sense. These records can help you do it with, contemporary information, not folklore.
Greg Hazelwood notes that these records would be eye-opening for his students because many of his students see the Moses myth of Harriet Tubman working on her own. But as you can see, other names and individuals were helping her out, re-emphasizing the notion that you've been telling us tonight, that this was a network of people.
Right. Usually organized in committees, functioning the way committees function, and she's a part of that. So I think those comments are dead on. And at the end of this presentation, I'm going to show you links so that you can get to all of these documents and resources online in originals or in transcripts, so you'll have all of the access you need to pursue it if you're interested.
Okay, and we do have a question about a source. Pearlie writes, what is the source of the letter to Gorsuch?
So this letter from William Paget to Edward Gorsuch appeared in Thomas Slaughter's book, Bloody Dawn, which is about the Christiana riot, and you can read it in its full context there.
And that was Bloody Dawn. Okay, well, shall we move ahead then?
Yeah, I think I want to wrap up the last part of this discussion and then open it up in the last few minutes to general comments and questions. But for me, the payoff from all of this activity and all of this emphasis on the collision of state and federal law is that it helps explain secession. If you look at the secession declarations, almost all of them invoke the fugitive crisis. Here's one from Texas in February. It says here at the end of it, they have for years past in the North encouraged and sustained lawless organizations to steal our slaves and prevent their recapture, and have repeatedly murdered Southern citizens while lawfully seeking their rendition. Now, that's not true necessarily, but I think the perception among white Southern politicians is that that's what was happening. They're exaggerating, but they're not completely disconnected from reality. The resistance to the federal law was real, and it was part of the problem, and it was creating a lot of the friction that was escalating the crisis in the 1850s. I think it's just as important as the territorial crisis. It's just as potent as bleeding Kansas. Now, not every historian sees it that way. But if you're interested in teaching this in a different fashion, there's a lot of new scholarship that emphasizes this. Eric Foner's book, Gateway to Freedom, will help you see it that way. It's a brand new study, and it's a powerful study, I think. Now, I also think this helps explain Abraham Lincoln. Abraham Lincoln was quieter on the fugitive issue than he was on the territorial crisis. When he debates Stephen Douglas, he tries to avoid talking about the fugitive issue. But the reason is not because he believed the fugitive law was good. I have here a quote from a private letter he wrote to one of his closest friends who lived in Kentucky in 1855. He says, "I acknowledge your rights and my obligations under the Constitution in regard to your slaves. I confess I hate to see the poor creatures hunted down and caught and carried back to their stripes and unrewarded toils, but I bite my lip and keep quiet." That's a very powerful expression. Private letter to one of his closest friends saying he bites his lip and keeps quiet. But you've got to ask your students, what does that mean in terms of policy? Like, what is he really keeping quiet about? And the answer that I find most persuasive is not that he's keeping quiet about all of the slaveholders' claims, and he's not keeping quiet about the fugitive law, the one thing he is willing to fight to protect is personal liberty for free blacks. We often characterize that first inaugural address as a conciliatory statement, trying to reach compromise. But listen to this passage on the fugitive issue from that address. He says, "There is much controversy about the delivering up of fugitives from service or labor. In any law upon this subject, ought not all the safeguards of liberty, known in civilized and humane jurisprudence, be introduced, so that a free man may not in any case be surrendered as a slave, and might not be well at the same time to provide by law for the enforcement of that clause in the Constitution which guarantees that the citizens of each state shall be entitled to all the privileges and immunities of the citizens in the several states." When he quotes the privileges and immunities clause of the Constitution, he's doing so with Roger Taney sitting right behind him. Roger Taney, the Chief Justice and author of the Dred Scott decision, who used that clause to explain why Dred Scott had no rights. It's almost as if Lincoln is mocking him here. He is saying explicitly that we will never give up on the personal liberty rights of free blacks, and that there has to be a way to enforce the Fugitive Slave Clause without denying personal liberty protections to blacks. And if you look at his private letters during the secession crisis and his policy recommendations here, that was his bottom line. The containment of slavery and personal liberty for free blacks. And on those two issues, he wasn't going to budge. And if he wasn't going to budge on those issues, then he wasn't going to compromise with the Southerners. All right, now, Richard, I rolled through the end of this conversation a little too fast, and we're running late, in effect, but we have about 10 minutes. So I want to pause and see, do you think there are some questions that you need to ask me to clarify things, or do other people want to step forward and make some comments or ask some questions?
Well, let's see. Let's see if we have any questions or comments. So this is a good opportunity to pose any questions or comments. Let's see. We have a question here about the state of Texas. We'll come to that. Maybe we'll save that one for the end. Any comments or questions here about Lincoln's attitude toward fugitive slaves and free blacks? Anything need clarification there? I don't see anything coming across, Matt. So why don't we move ahead to our final point?
Okay. So I've been referencing these further resources. This slide gives you some links here. So first of all of the documents that I've been describing, the Vigilance Committee records, the state laws, the federal laws, the Supreme Court cases, a whole host of other resources, including published and unpublished accounts. They're all available through this Underground Railroad Research Guide, which I'd urge you to take a look at it. It will help you extend this discussion. We've also created an Underground Railroad digital classroom, which has things like the Google Earth tour of Henry Brown's escape, an exhibit describing how to build the box yourself if you want to do it to scale, and a host of other documents, including that document from William Paget to Edward Gorsuch. And then I've written 2 short essays designed for teachers that are now available freely online at this new site I've created, which is kind of like a multimedia survey of U.S. history. So one of them is on how to explain the Underground Railroad and its impact on the coming of the war. That's a very short essay. The other one's a little longer, but it really covers everything we just covered. So if you want a kind of 20-page version of this class in a written form, interpreting the Upper Ground Railroad is an essay that I wrote that you could use to extend it.
Okay, now let's get to that final question. We were talking earlier about Texas, and Pearlie writes, speaking of Texas, the state has revised the way in which it teaches slavery to make it appear a relatively minor, to make slavery appear relatively minor in American history. Your views? I think I know what your views might be, but why don't you share those with us, Matt?
Right. So no surprise, I find that a little appalling. Obviously, slavery is the central battle in American history. One of the things I'm hoping states like Texas will realize, if you focus on the fugitive issue, it's Northerners who are invoking states' rights and Southerners in the 1850s who are invoking federal power. Actually, the state of Wisconsin in 1854 attempted to nullify the federal fugitive slave law. I mean, most of us only teach nullification in connection with South Carolina. But nullification was a doctrine that some northern states experimented with when it came to the fugitive crisis. So, that raises the question of how sincere Southerners were when they invoked states' rights during secession. It seems to be, in retrospect, an example of where you stand depends on where you sit. When they had federal power, they used it for slavery. When they lost federal power, they turned to state power to protect it. That's how I see it anyway.
Okay. Well, ladies and gentlemen, we have come to the end of our webinar this evening. Any final questions or comments? I see we have some people typing. Let's see. Thank you. Well, you're welcome. Let's see anything else. Any questions or comments coming in? Okay. Well, ladies and gentlemen, please check out the Underground Railroad lesson. I think you'll find that very interesting and very useful for your students. And it's got as I said earlier, it's got a wonderful interactive exercise that I think will be both engaging and instructive. Check us out on Facebook. We regularly post material on Facebook. It's a great way to stay in touch with the American class from the National Humanities Center. Matt, I want to thank you for this excellent webinar. You've given us a whole new view of the Underground Railroad. Thank you very much.
Hey, it was great to be here. On the anniversary of the Gettysburg Address, I might add, as we closed with Lincoln.
Oh, yeah, okay. And I want to thank our participants for their intelligent participation this evening. Thank you very much. Please don't forget to submit your evaluations to us, and as soon as we get those, we'll send you documentation of participation. For those of you who have been with us throughout the fall, thank you for your participation in all of our webinars. And let me remind you that our spring webinars are open for registration. People are signing up for them now. Please take a look at them. We'd love to have you back with us again next spring. So for tonight and this semester, ladies and gentlemen, thank you and good evening.